Good morning. Today we are going to discuss the topic administration of justice. Okay, the two most essential functions of the state are what? War and administration of justice. Here we are concerned with administration of justice. If a state is incapable of performing the functions, then it should not be called as a state. It is a failure of the state. If a state is incapable of performing these functions, it cannot be called the state. Administration of justice implies maintenance of peace, order within a political community. Means there are certain objectives, there are certain functions of the state, and justice performing or administration of justice is one of the main function. Okay. Now, what is administration of justice? It means providing peace to the people, providing law and order to the people. So, justice is the main thing. Justice should be achieved by the government, by the state. The state has to provide justice for its people. Therefore, administration of justice is the firmest pillar of the government. We are having one statement called as herd of wolves are quieter than men unless they are controlled by some authority. Herd of wolves are quieter than men. It means that the man is not quieter. Why law was created? Because people are not following the provisions, the simple things in the society. There are some crooked people in the society. To control the crooked people and to guide the right people, law is being created. So if a person does not follow, violates the law, the other person can go approach to the court. Therefore the courts are there and they provide justice. The court says that yes, this is right and this is wrong. You have done the wrong. You will be liable. You have to compensate him or you will be punished. So for that law is there. Law is there for providing justice. I'll read the statement. Herd of wolf is quieter and more at one than so many men, unless they all have one reason in them or have power over them. One reasoning is not possible. Unanimous decision is in rarest matter. Therefore, one reasoning of all the people is not there. There will be thesis, there is an antithesis only, isn't it? Therefore, controlling these persons is very much important. One power over them is required. Now, how this administration has been evolved? In the ancient times, we have seen what was the principle? Might is right. Whoever was mighty, he was considered to be right because he was powerful. He used to get justice for his own purpose. He used to justify his own objectives and do whatever he likes. The other person was weak and he was succumbed. Therefore, the first stage, or you can say the origin and the first stage of administration of justice is what? Might was right. Slowly afterwards, development have taken place and we became politically organized. A state was formed. Therefore, the concept of justice emerged. Political state has been formed. Justice has emerged. Concept of justice has emerged. The scale has emerged. Therefore, here the principles came as what? If you are responsible, if you have done a wrong, then you are liable. An eye for an eye and a tooth for a tooth. Okay, this was a principle on which the state was doing its administration of justice. This is the second stage. The third stage, we already have become politically formed, politically conscious, but now we are being developed. The scale, the concept, the principles have very much emerged, and therefore the third stage is what? The developed stage. State began to act as a judge to assess the liability and the penalty. Therefore, public justice came into existence. The courts came into existence. Therefore, the main function of administration of justice is what? Providing justice, giving justice to the people. So, the functions, the administration having mainly two functions. One is primary function. Primary function is what? Administration of criminal justice. Means the primary function what we are going to see? Administration of criminal justice. And the second is what? Administration of civil justice. So first we are going to see about administration of criminal justice. Now the whole criminal justice is based upon its own theories, which are called as theories of punishment. Because when a criminal justice concept comes, we say that the accused will be punished. Therefore, the punishment is a thing which is given in the hands of the court to the concerned accused when the case is being proved. Therefore, the theory of punishment is very much important here, because punishment is the remedy. Punishment is the objective of criminal justice. The wrongdoer must be punished. The innocent should never be punished. The wrongdoer should be surely punished. Okay. Now this concept is based upon certain theories which are called as theories of punishment. That is deterrent theory, retributive theory, then reformative theory, then preventive theory, compensatory theory. These are certain theories. We are going to see these theories in deep in our lectures on criminology. Okay. Now here we will see in short. First theory is what? Deterrent theory. How the punishment should be there. The jurists believed that punishment should be in such a manner that the people should get deterred. The concerned offender will be punished, but it will work on the mind of others also. Other people are going to get deterred, so that the crime control will be there. The toll of crime will become less. They should get deterred. Therefore, severe punishment should be given to the offender. It will work on his mind also, because he will see the sufferance and the pains, and he will say that I will not commit hereafter any type of crime. So punishment should be deterrent. It should work on the mind of the offender, and also should work on the mind of others, because the others will consider that okay, we should not commit a crime because this is the repercussion, these are the consequences. This is a deterrent theory. The other theory is what? Preventive theory. Preventive theory means to prevent the offense, to prevent the crime. Prevention is always better than cure. So we are having certain preventive concept also. Preventive retention laws are also there, so that the person should not commit a crime. But this theory is also having certain limitations. The first offender cannot be prevented. There are many crimes which we see that they cannot be, they happen. The offender does it. So certain things can be prevented. In that area, in a limited scope, preventive theory is working. For that we are having many concepts like where the person is being arrested and detained only because why? He may commit a crime. These preventive retention laws are there in our country also. Okay. Now preventive theory. The third is what? Retributive theory. Retributive theory means tit for tat. The person has done a wrong, the person has made suffered the other people, the innocent people. He has created certain things in the society, so he should be punished. Retributive, tit for tat, an eye for an eye and a tooth for a tooth. This theory is having also its own limitation, because this is going to continue. The concept of revenge is going to continue. It will just shift from one shoulder to the other shoulder. So it is not proper. Somewhere it should stop. You cannot take law in your own hand. It is the judiciary which will punish, and they will see the scale, and they will calculate, and then they are going to punish. So tit for tat and all, that is not that you can't say that it is completely improper. In certain aspect we have to apply this, but we have to calculate the liability, assess the liability, and then provide for punishment. Okay. Now the next theory is what? Reformative theory. Reformative theory is you can say is vogue in now. Our legal system is based upon reformative theory only. They believe that don't see the past. He has done the offense. Okay. There are certain circumstances because of which the man commits crime. Again, this topic we are going to see deeply in the lectures, of criminology. Okay. Now, when a man commits a crime, maybe there are certain situations which compelled him to commit a crime. Now, these situations are responsible then. No one is born criminal. So, based upon these aspects, this theory has emerged called as reformative theory, and we try to reform. Like the concept of parole, probation, we have created this based upon reformative theory only. Hate the sin, not the sinner. That is the base of reformative theory. Man is not a born criminal. Man can get reformed. These aspects are there. But excessive reformation should not be there. Because if excessive reformation is there, you are taking care of the offender. What about the victim? Or the legal representatives of the victim, isn't it? Therefore, excessive reformation should not be there. Wherever possible, wherever it is required, their reformation must be there. And wherever required, deterrence must be there. Unless that, crime will not be controlled. Okay. Now the next theory is what? Compensatory theory. Victimology has come into existence. This is a new aspect which we study about victimology. See to the victim and all, and provide for compensation. Because though money is not an answer for all the things, but it will help those people, help those victims. Therefore, the person should be properly compensated. This is compensatory theory. These topics or this discussion which we have done, we are going to see it deeply in criminology. Okay, why man commits crime, and if he commits a crime, then how penology works, what are the principles or the objectives of penology. Okay, here just consider administration of justice in criminal aspect is what? Punishment. The offender should be punished. There are different types of punishment. Capital sentence is there, fine is there, imprisonment is there, life imprisonment is there, solitary confinement is there. We have seen these types of punishment in BNS, Bharatiya Nyaya Sanhita, isn't it? And newly one punishment is being introduced, that is called as community service. Now the community service is again based upon which theory? Reformative theory. And in ancient times, more different types of punishments were there, like flogging was there, whipping was there, mutilation was there, banishment was there, deportation was there, pillory was there. Many types of punishment at ancient times were there. But now we are only having capital punishment, life imprisonment, rigorous or simple, fine is there, forfeiture of property is there, and the newly introduced concept, that is community service, is also there. Okay, bye bye. See you in the next video.